So these are the obligations which the organization need to pick up, right? So this is something which, in line with Madhav, you asked a question like what I need to do as an entity, isn't it? So data fiduciary is responsible for ensuring compliance with the Act's provisions, right? So your first and foremost thing is to understand what is your obligations. If you don't know your obligation, like the way we discussed territorial scope, if you don't know what is the law is expecting out from you to do, this is going to be a complete failure. So first and foremost is to understand what are your obligations. Then accordingly, you can define your entire process basis that. Privacy notice, the most important element to ensure transparency is that your privacy notice. So majority of the transactions are going to be consent based, and if it's going to be consent, you have to give a privacy notice. For non-consent based transaction under the DPDP Act, you don't need a privacy notice. Whereas in GDPR, irrespective of your lawful basis, you need to provide a transparent information before collecting personal data. There is a very big difference here, correct? Whereas the law says, Indian law says, you don't need to give a, a privacy notice for non-consent based processing, right? Which is basically your legitimate users, right? So the another important point that you need to be aware of is that we use privacy notice, or we may use different terms, right? You can call it as a privacy policy, you can call it as a privacy disclosure, or you can call it as a privacy statement. It doesn't matter. What is important is that you need to provide a clear and transparent information to the user before collecting their personal data, right? So that's the most important requirement. So what you need to do as an Indian entity, you need to give privacy notice for all the data that is collected prior to the enforcement of the law, and you need to now facilitate that notice in 22 languages, right? Initially you can give it in English, and later on, basis the requirement of the data subject, you need to customize this and provide into 22 languages, which is recognized in the Schedule 2 of the Constitution, right? So this is very, very important. If you are handling B2C, this is an activity you need to pick up very, very quickly, right? Otherwise we will have a direct violation there, isn't it? So the next is your accuracy and completeness. Ensure the data that whatever you collect is correct. If there is a inaccuracy in the collected data, then it leads to subsequent wrong decisions taken basis the data. Have appropriate technical and organizational measures. This is a very, very important step, because you need to do a very strong assessment in terms of how do you handle and protect your data within your organization, right? So typically your gap assessments can give you a high level overview in terms of how the technical and organizational measures are implemented, but a detailed data privacy audit is the one which gives you assurance. There is a difference between a gap assessment and an audit, right? So basically anyone who does, typically I do a lot of gap assessment. So what I do part of a gap assessment is I ask a question which is required by the law, and I just go with the answer what is provided by my respondent, right? So I may not ask them an evidence to prove whatever they state. Of course we make it very, very clear that it is your organization. If you factually give a wrong statement, then that gets recorded, and the consequence is going to be faced by that individual or the organization. But whereas when I take an audit approach, I'm going to ask them in terms of a clear evidence to substantiate what statement they make, correct? So that's a major difference. So it's recommended that we prepare towards a privacy audit, right? And we do a thorough evaluation of our organization and try to identify the gaps and subsequently build those controls and framework to protect the data, right? So that's your Tom. We call it as technical and organizational measures. All right. So next is notification of data breach. It's very important for organization to understand what is their notification requirement, right? This is again a very important topic we are going to discuss with lot of case studies when we go to the data breach chapter, where what constitutes a breach, what's the difference between an incident and a breach, and what will be the criteria for notification, and how quickly you need to notify, how do you do a breach impact assessment. So all these things we are going to discuss in a detailed chapter. That's again a very important obligation, right? So this is very different from your security incident, where usually there is limited audience whom you need to inform about a security incident or a security breach. Most of the time the organization try to brush it under the carpet, not revealing that actually a breach happened. Unless and until the authorities come and knock your doors and ask you tough questions, usually you try to hide it, right? But whereas in a privacy breach, the law has kept it more stringent, right? You need to notify not only to the authority, but you will need to notify even the data subjects, right? That you will not usually see in the information security standards, correct? So that might have been told more of a guideline, but not mandated in most of the cases. Now most of the certains have sort of mandated that, but I don't know how much is the organization usually follow that. All right. Cross-border data transfer of personal data, another very very important topic, where why the organizations are subjected to more scrutiny when they transfer data outside the borders. The reason is very simple, like the case we discussed about the territorial scope, the authorities will become slightly helpless in terms of monitoring or controlling or even enforcing anything of the law when the data goes out of their territory, correct? So that's where they keep very stringent measure when it comes to cross-border data transfer. Especially in GDPR, you will see more stringent measures, like you need to do a transfer impact assessment except for the case of adequacy decision, right? In the rest of all the appropriate safeguard, you need to do a detailed transfer impact assessment. As of now in the Indian law, they have kept it very very simple, that you need to look at the blacklist set of countries, and except that you are free to do your transfers. I think the rules will definitely have more specific requirements called out part of this. And another important element is like not only the law, there are regulatory requirements which you need to be mindful, right? For example, customer transaction data which is coming from a bank cannot leave India. There is a strict data localization requirement which is enforced by RBI, right? So RBI has mandated that banks cannot export the data outside the Indian jurisdiction if it involves customers' banking data. That can also fall under personal data, isn't it? So those sectoral requirements is also something which is very important. You need to be mindful. This goes to the point number one again, correct? So processing vulnerable people's data in terms of, it could be minors data or people with disabilities. So they have challenges in terms of understanding, or sometimes their consent could be invalid. So in this case, you need to be mindful that this data processing can have a lot of restriction, especially if you are trying to do any behavioral monitoring or any tracking or targeted advertisement. This is strictly a big no-no, and this has been called a common element both in GDPR as well as DPDP Act. So this is something which the organization needs to be mindful. Another important point, if your processing involves any element of children's or people with disabilities, then you need to have special attention towards it. If you do any tracking, behavioral monitoring or targeted advertisement, you will be under the radar and you might get penalty for that. All right. The next is valid contracts, another important aspect in terms of engaging with a processor part of your equation. We already emphasized about this. So the Indian law puts a very high level of accountability on the fiduciary, right? Because the fiduciary will face the entire brunt if there is a breach that occurs at a processor or at a sub-processor. Whereas in the GDPR law, if you see, the GDPR has called out protecting personal data is an independent obligation on the processor, right? Irrespective of what the controller has dictated in the contracting agreement, the processor has to independently protect the personal data. It's a independent obligations under GDPR. Whereas if you see in the Indian law, there is no direct obligation on the processor, which means the fiduciary have to be more scrutinized in terms of their selection of processor and subprocessor. So two elements which, if I have to vouch that these two has gonna will become more broad and very important activity in the Indian scenario, is going to be data subject rights, and second is vendor due diligence, right? So vendor due diligence is going to take a very big difference in terms of selecting the processor and sub-processor is going to become a very important process, right? You need to do a proper due diligence, get the sufficient warranty and guarantee before choosing them. It could be done in different ways, right? We're going to discuss that in a vendor due diligence chapter. All right. So data retention and erasure, in terms of how the data is going to be retained, how long, what is the criteria, those things will be again discussed in the detailed chapter. Grievance redressal, we discussed about that. Significant data fiduciary, these are the direct obligation. You need to appoint a DPO. You need to have a data auditor, independent data auditor has to be appointed, and you need to do a DPIA, right? So these are the three direct obligations which have been specifically called out if you fall under the category of significant data fiduciary.